once upon a time, I met a lawyer, and he had worked for several school districts for a few years, and he gave me a little talk, and it went like this. A district will always take parents much more seriously once they file for due process. Until they file for due process, no matter how strong the case is, generally the district is going to think that the parents aren't serious, don't have the evidence they need, and furthermore, until the parents file for due process, the district's really not under any compulsion to change anything. So I had been kind of collaborative in my orientation, and I figured if a case was a bad case for the district, they would settle it at the IEP level or before due process, because that could save so much money. But systemically, the system doesn't generally work that way. We could analyze why, but just trust me on this. If you want to be taken seriously, in 9 times out of 10 in these situations, you have to file for due process. So that was kind of the advice from my district mole. And once I began to plug that in, along with some of his other fly-on-the-wall observations about how districts work, I found that I was much more successful in actually getting somewhere and sooner. So that's kind of the thing about due process, is it starts a clock running, and the district has to respond within a very set time frame, as you'll see. When do you file for due process? Well, you file for due process when there's a disagreement that you haven't been able to resolve through the IEP meeting. So why would you file, and what are your remedies? Well, you would file to change your placement or services that are in the IEP, to seek compensatory education for the district's failure to offer a free appropriate public education in the prior 2 years, to get an independent educational evaluation if the district says no, their assessment is appropriate. And one little note is that you cannot use this process of filing for due process to get money damages against the school district. Those would be civil remedies under the ADA or Section 504 or even Section 1983. So we're not talking about monetary damages. However, when you bring a case under IDEA, if you prevail, the district is required to reimburse you, parent, for reasonable attorney's fees. And so that's in there because Congress, when they initially developed the IDEA, understood that it would be a statute with no real teeth if there wasn't a way to enforce remedies. So they came up with a fee-shifting statute as a way for parents to be able to get lawyers to help them with their disputes and get the lawyer paid at the end of the dispute. So we can take more questions about types of retainers, contingent and not contingent, if people have questions about that. But anyway.
I think that's a good point, though, Bonnie, because a lot of people, when you say file due process, a lot of people get like, there's no way I can afford that. And it's still worthwhile for them to have the discussion with a lawyer about, is there the potential, is the case strong enough for a lawyer to take it on a contingency basis?
That's exactly right.
Okay.
That should always be asked. And, our firm works hard to look at people's actually, financial wherewithal and, factor that in as a consideration too. If the case is strong, we think we can get our fees at the end of the dispute, we may be able to make, special arrangements for that client. Anyway, any work done in preparation of a due process is reimbursable with the exception of attending a resolution session, which we'll talk about in a little bit. IEP meetings are not reimbursable on the theory that until the IEP meeting is over, you haven't really kind of catalyzed a live dispute. So IEP meeting attendance is expensive and presents problems for us in cases where we do represent the client on a contingent fee basis. Sometimes the best we can do is a telephonic. Sometimes the best we can do is just prep the client for the IEP, but we always do at least that. Anyway, through due process, we've obtained, compensatory education for academic, speech, OT, and transition. We've been able to change placements either to non-public schools or into public school with related services, behavior intervention through a non-public agency, services in general through non-public agencies, residential treatment programs, which are always very expensive, often in excess of $150,000 a year, and reimbursement for out of pocket costs for funding either placement or services or both. So due process is a procedure that ensures that parents have a way to assert their rights as well as those of their child regarding special education. In California, we work with the Office of Administrative Hearings. They're Sacramento based. They also do the regional center hearings. Um, and after the due process is filed, if the parties do not resolve it at a resolution session or mediation, then the parent can actually proceed with the hearing. Now, the hearing is basically like a trial, except for a couple of things. It's not in a courtroom, it's usually in a conference room, and it's not recorded by a stenographer, it's audio recorded by the hearing officer. And the hearing officer is the only decider, there's no jury, and his decision is appealable. But you basically are looking at preparing for what will likely be at least a 5-day trial on the issue of whatever it is that's being raised. The district's offer wasn't FAPE. The district's assessment was inappropriate. The district failed to implement my IEP properly, et cetera. If you lose the hearing, you have the ability to appeal within 90 days. You must appeal within 90 days in California. And on appeal, all of the services in your last agreed upon IEP are stay put. So there are some different remedies available to parents, and they tend to gravitate, understandably, toward informal dispute resolution because it sounds good, it sounds less expensive, and parents don't want to, end their collaborative relationship with the district. Problem is, alternative dispute resolution almost never works. Because no attorney involvement is allowed, and the district kind of really controls the agenda, and they take advantage of the parents who don't really know what their case is worth, and they offer them very low ball offers. We don't do ADRs because generally district policy is that attorneys can't participate in them, but what we do get is parental attempts to settle the case at due process that haven't been successful. Meanwhile, the clock is running in terms of what they can file on, and it's possible that they have lost a very good IEP, very actionable IEP, because you can only go back 2 years. So the goal, I think, once you realize you have a problem, is to get out of the IEP level of things and get into due process as quickly as possible. Assuming you have the evidence that you need to be ready, like you have, an evaluator who can testify as to what the child's needs were or whatever. So we've talked about kind of the mediation only, alternative dispute resolution. There's just not a lot of pressure on the district to settle, and they don't usually settle. When we file for due process, the hearing office gets the case, and they issue a case number, and then certain things start to happen. One thing is, we're filing a complaint, and the district is required to provide an answer, a written answer. And so that is interesting in that it sometimes gives you some insight into how the district is thinking about the case. But a lot of the time, it's just kind of blanket, disclaimers like, we don't agree that our evaluation was inappropriate. We think that the mild to moderate autism class was an appropriate placement, blah, blah, blah. But sometimes they're a little bit more transparent. When you file for due process, you are going to get 2 opportunities to settle before the actual hearing. The first one is resolution session. The second one is mediation. We're going to talk about those. But I wanted to say first that either parents or the district can file for due process, although the district's grounds are kind of limited. It's usually going to be about the appropriateness of a services or placement or an evaluation. A parent, on the other hand, in California can file for due process up to but no more than 2 years from a triggering event. So that could mean an IEP, an assessment, a district failure to do something that you've asked them to do that you believe they're legally obligated to do. And you can also file at any time for any matter relating to the identification, evaluation, or educational placement of a child, or the act of providing a FAPE for the child. So this means that you can file if there's a disagreement about any of the above. There's different kinds of violations. Some are substantive, some are procedural. I'm not going to really get into that today. I think we could have a whole separate discussion on, just what's in a due process complaint and how you allege, appropriately, how you allege violations of IDEA. But anyway, if you have either a procedural violation with substantive harm or a substantive violation, you can file for due process. And so that gets the whole thing going. And then the hearing office quickly kicks back a scheduling order with a mediation date and hearing dates. Now, you notice I said there was a resolution session. The district is responsible for scheduling that. I believe it's within 10 days of receipt of the complaint. And what that is, it's supposed to be an expanded IEP team meeting at which you can talk about what it would take to resolve your case. Now, it used to be the case that I thought that going to resolution sessions was valuable because it sort of forced the district to start thinking about the case. But lately, districts are so overwhelmed and disorganized that you sort of get there, you get somebody from the district to sit down with you, and they say, oh, I've just gotten this, I have to look at it, let's talk about mediation. So lately, we've just been, going to mediation instead. But, if you were to attend a resolution session, you can definitely negotiate placement and attorney's fees, but there's no attorney's fees for actual attendance at the resolution session because Congress set it up that way because they were hearing a lot from school districts about outrageousness of attorney's fees, and they decided to build in one more chance to settle without fees. That said, preparation for the resolution session or completing any settlement agreement generated from a resolution session would still be reimbursable. So, I think it's just kind of a thing that comes in and out of fashion. Right now it's out of fashion. So instead we're, usually mediating cases and in most cases we are able to settle at the mediation or after, but before hearing. So, districts do really look up and start paying attention. And it's interesting, I have a case that I had to file on, I think about a week ago, kind of doing an abbreviated filing, and then I'll amend it later because the statute of limitations was going to run. And interestingly, yesterday I got a letter from the school district, and they've offered me a settlement offer for a non-public school for the client, but only for 1 year and not subject to stay put. But that tells me that that district thinks there's something very wrong with what happened in the last year or so, because that's really the only situation in which you see somebody sending you a settlement agreement before filing for due process. So it does happen, but it's very rare, and it's always enjoyable because it tells you you're on the right track. Anyway, just going back to kind of your more substantive case, you'll be looking at whether you'll be putting on evidence about the fact that the district's placement offer didn't constitute a free, appropriate public education. And the parent has the burden of proof, which means they have to prove that it's more probable than not that the district's offer didn't constitute FAPE. And just, going back to some of our other discussions, the current definition of FAPE is that basically the school has to offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Now that is the language in Andrew, which we talked about, I don't know, a month or so ago. In terms of winning, which is always kind of the goal, if there are procedural violations, those are the easiest ones to win on, whereas a substantive violation is more a subjective matter of opinion. So let me give you an example of a procedural violation that would be a dead bang loser for the district. Let's say the district failed to make a specific written offer of placement at the IEP meeting, so the parent could not figure out what the offer was. That would be bad. Let's say the district refused to consider input from the parents. That would be bad. Let's say the district made a placement offer without going through the prior steps of eligibility, present levels of performance, goals, and services. That would be bad, and so on. So the best cases are the ones you can prove were procedural violations. Substantive violations come back to this whole question of did the district offer FAPE? And that's what your preparation would be involving, was showing that the district's offer didn't constitute FAPE. Now, in terms of FAPE, just a reminder, the district is not supposed to be obligated to, or the district isn't obligated to give you the best program. They are only required to give you a substantively appropriate program. The district has an obligation to identify, locate, and evaluate all kids with disabilities whom the district suspects of having a disability who are nonetheless advancing from grade to grade. This obligation is triggered whenever there's reason, excuse me about the paper rattling, for the district to suspect that the child has a disability and reason to suspect that special education services may be needed to address that disability. If you disagree with the district's evaluation, that would be another ground for going to due process, as would concerns about the appropriateness of the educational placement by the district. And then, as we talked about, if the district wrote an excellent IEP but they failed to implement it, that's another grounds for going to due process. And those are generally dead bang losers for the district. If you've got a document that clearly states, you're supposed to have 60 minutes a week of individual speech and you missed, 30 sessions, the remedy is going to be speech therapy services, but that would be a loser for the district. And in theory, if an attorney had brought that case, the district would be on the hook for reasonable attorney's fees. So we also didn't talk about what the district does when they get a filing from you. And what they do is they prepare, an answer to the complaint. This has to be done within 10 days of the receipt of the parent's complaint. It's sort of analogous to in court. If somebody files a civil lawsuit, the defendant has to answer within 30 days. However, unlike civil court, we aren't seeing that, OAH is dismissing people's complaints we aren't seeing any penalty, I should say, on the part of the school district if they fail to answer the complaint, but most of them do it. And it'll basically be their thought process about why the complaint is not accurate and why they've offered FAPE. But I always look at those to sort of see if there's anything interesting in there. Usually it's pretty boilerplate. So we've talked about we've talked about the complaint, we've talked about the resolution session. It's supposed to be mandatory, but interestingly, we're seeing a lot of districts waiving it. Once you've got your hearing dates and stuff like that, then where you're at basically is preparation for hearing and all the things that need to be done to prepare for hearing.